People are probably wondering why I always put my son's photos in these videos. It's because he was traumatized by CPS for many years in his childhood into his adulthood. And basically, I believe that the reasons that he started doing fentanyl at all were because of what CPS did to him and how they traumatized him so many times. But in this particular video, the evidence that she is talking about, the exhibits that she's referring to that she's saying are public documents, were all dependency orders from my son's previous case. He was alive at the time of this trial, but I just think it's just weird how they used like all of his dependency orders and not my daughter's, because my daughter was also involved in a dependency, but they selectively chose him to target, and I just find it weird because he ended up passing away, and they told me to put him out when around that time, so I feel like it's kind of like their fault. But that's the reason why he's in most of these videos, because I feel like they did him, wrong. And I mean, it's his fault. He did it. He did the drugs himself. But I think that the reason why he did them and the reason why he was suicidal was because of being traumatized as a child. Children are very sensitive, and he is too. And we can't just expect them to be tough because they're not. They're very sensitive, and they're new to this. So, and she didn't care. This judge could care less, and she knew my son was there listening to the trial, and it didn't affect her one bit, and so even now it doesn't affect her. She does not care about anybody's children. But all the exhibits that they're talking about in this video are dependency orders from my son from when he was a child, and from the daughter that we're talking about right now. So there are previous dependency orders that were not public documents. So just so you know, that's what she's talking about in each of the exhibits. And they don't really say anything except that I signed because I was stupid back then. I used to sign all the time. I don't do that anymore. But I signed these dependency orders in the past, and I agreed that my children were dependent. And now that I know more, I would have never done that before had I known. But I just had to give you an update of what this.
Um, so we are here to begin trial this afternoon. I want to let the parties know what I received and reviewed, and then we can talk about whether this will be an entirely remote trial or if anyone wishes to appear in person, and then we'll talk about scheduling. So I did review a brief from Ms. Cowan, a brief from Mr. LaRosse, and 2 emails and an attachment pleading from Ms. Zayas. Am I missing anything? I also have the exhibit list and the witness time estimate. Am I missing anything from any party beginning, Mr.?
I don't believe so, but in regards to the emails from Ms. Zayas, I'm sorry, I didn't have a chance to check if these were filed, but one was entitled as exhibit list, 23 pages, although it's not really an exhibit list, it's more of a trial brief, and the other was the reply to AAG's trial report, which is 3 pages. Is that what the court was referring to?
Yes.
Okay, thank you. I think that's it then.
All right. And there was some content in the email, so we have filed all of the emails that we received, so they should be in script if you want to make sure that you received them and have been able to review them. So anything else from DCYF or from the CASA?
In regards to filings?
Yes.
No, not from the department. Thank you.
Okay.
And Your Honor, Ms. Johnston-Hanks did file a report to court, but I have not submitted that as an exhibit. At this time, I may upload it into share file, and I will make sure that Ms. Zayas and Mr. LaRosse get a copy of it if I intend to introduce it as an exhibit. Thank you.
Thank you. And Ms. Zayas, I'm sorry, go ahead, Mr. LaRosse.
It just occurred to me that I did send the court and the parties a form FFCL for termination trials. It had nothing specific to this trial.
Yes, I did see that.
Okay.
Yes, thank you. Ms. Zayas, I did review, let me tell you the documents that I reviewed that we received from you, just to make sure I've got everything. So I did receive an email dated Friday, 7/15, 9:38 p.m. I received an email indicating that your only witness would be your son. So I received that. That was July 15th at 4:30 p.m. I received your exhibit list and your trial report. So did I list everything that you've submitted to the court, Ms. Zayas?
Yes.
Thank you. All right. The next issue I'd like to take up is the nature of the proceedings. So everyone has appeared by Zoom today, and the court is happy to conduct this trial by Zoom if that is the wish of all of the participants. The court is also happy to have any of the participants in person in my courtroom at any time. So everyone is welcome to come. If you were to be here in person, the only requirement is that everyone in the courtroom has to wear masks. And so other than that, we are pretty much open and operating normally pre-pandemic. So let me just ask first, Mr. LaRosse, does the state wish for the trial to proceed by Zoom?
I am perfectly comfortable and in fact in favor of that, Your Honor. However, I do want to state that I think that even if all the parties are in agreement, it's still necessary for the court to conduct a Matthews v. Eldridge balancing test, which I would like to address after the court checks with everybody.
All right, very good. Ms. Cowan, what is your preference for the nature of the proceedings?
Yes, Your Honor. Ms. Johnston-Hanks and I would prefer to appear by Zoom if the court allows us to, and I agree with Mr. LaRosse to address the Matthews factors as he has briefed in his trial brief before the court makes a decision. Thank you.
Okay. And Ms. Zayas, what is your preference, to have the trial by Zoom or to come in person?
It's fine by Zoom.
Okay. And let me ask you this, Ms. Zayas, can you tell me whether or not appearing by Zoom is better for you than coming in person every day? What's the best way for you to have access to this proceeding?
Well, if my rights get terminated by Zoom, I'll be mad at Zoom. So I don't know.
Are you able to come in person every day?
I can if you want me to. It doesn't. I don't know. It doesn't matter. But I guess Zoom is fine for now.
Okay. Is Zoom more convenient for you?
Yeah.
Okay. And I see that you have your child with you. If we had these proceedings in person, would you be able to find care for your child?
No, I have to bring her with me. She's not in daycare yet. Or actually, I can son watch her, but I don't know. I have to ask him.
Okay. So you don't have childcare lined up if we were to conduct these proceedings in person?
No, Maya's been to all the child cares around here, so they don't tell me they have an opening.
Okay. Thank you. And I don't need to know your precise location, but how far away from the King County Courthouse in downtown Seattle are you?
Oh, downtown Seattle? Probably like 45 minutes.
Okay. And do you have reliable transportation to the downtown courthouse?
Yeah.
All right. Is there anything else that makes appearing by Zoom more convenient for you that I've missed?
No, that's it.
Okay. Thank you very much. All right. Mr. LaRosse, go ahead.
Yes, thank you, Your Honor. So I provided some briefing in the trial memorandum regarding the requirements on an individualized basis for the court to determine whether, in a specific case, a hybrid trial or a full Zoom trial comports with due process. And the test to be employed is the Matthews v. Eldridge test, which requires the court to balance three different factors. One is the private interest at stake, one is the state interests at stake, and one is the risk of erroneous deprivation if the procedure that is being contemplated is used in lieu of having everyone else appear, having all of the parties and witnesses appear in person in the court. And in terms of the private interest, we have the interest of the mother, which is her fundamental right to parent the child. We have the interest of the child, which is a right to rapid establishment of permanency in a safe, stable, and appropriate home. And then in regards to the state's interest, the state shares the same interest as the child, which is that right to establishment of permanency for a child who's been in out-of-home care for some 2+ years. All of the parties also share an interest, however, in not getting COVID. And given the prevalence of the new BA.5 variant, Ms. Zayas can speak to her susceptibility given her particular medical issues. I am someone who is particularly susceptible or at a higher risk of problems given my own medical circumstances if I were to be exposed to COVID. And so I definitely have a strong interest in not putting myself at risk to that. I believe Ms. Zayas has the same. I don't know about the other parties. And then the next, so I guess I would summarize by saying that the various private and state interests are all of comparable weight and not necessarily determinative of the question, which really rests then on the question of a risk of erroneous deprivation. And the primary considerations in terms of risk of erroneous deprivation by use of Zoom at trial are essentially the ability of the parent to fully participate and the impact on the use of Zoom on the parent's ability to effectively work with their counsel. The second of those is moot because Ms. Zayas is representing herself. So whether we proceed by Zoom or in court, the question of adequate ability to work with counsel is not at issue here. Ms. Zayas has indicated that she would prefer to appear by Zoom. The court has obviously been using Zoom for the past 2.5 years to conduct its trials. I will note that in many of those trials, judges have observed that Zoom is actually in some sense preferable due to the fact that they are able to have a full face-on view of the witnesses without masks. And were there to be a trial in person in the courtroom, the court would be having a side view of witnesses wearing masks. And so that's actually a detriment compared to the ability to observe the witnesses via Zoom and also potentially to understand them because of the lack of obstructing masks. So there is not a risk of erroneous deprivation that is presented by conducting these proceedings via Zoom, and therefore the department is requesting a finding from the court that proceeding in this manner does comport with due process. Thank you.
Thank you. Ms. Cowan, would you like to add anything?
No, Your Honor. Thank you.
All right. Ms. Zayas, Mr. LaRosse suggested that you might have some health concerns that would be relevant to whether it would be safe for you to come to court. Would you like to generally tell the court whether that's correct or not?
I'm not taking any medication right now, but sometimes I get high blood pressure, but I haven't had it in a while, since about 6 months after having the baby, so not right now.
Okay. So you don't have any issues that make you particularly susceptible to complications if you were to contract COVID?
I've had COVID already. Being old, I guess, but I've already had it. I had it a year ago. Okay. Me and baby both had it.
Thank you, Ms. Zayas. All right, so the court will observe that having done numerous Zoom trials, the representations that Mr. LaRosse makes about the court's ability to perceive witnesses and make credibility determinations and the effectiveness of the Zoom platform for trial for counsel and parties to be able to do the same is correct. If we were all in person, we'd all be wearing masks, and not only would the witnesses be wearing an awkward, clear face mask that is transparent, but it does obstruct some facial expressions. But the parties and the lawyers wouldn't be able to view each other in a way that might be important. For example, Ms. Zayas wouldn't be able to view Mr. LaRossa's face at all times, and that might be detrimental to her presentation of her case. So as far as any right of confronting witnesses and the ability to confront witnesses and gauge credibility, that is in some ways enhanced by the Zoom platform as opposed to being in person. Mr. LaRosse does have health concerns that require this court to balance protecting his health risks with an in-person trial. And frankly, given Ms. Zayas' preference for a remote trial and the hardship that she would suffer in having to find childcare for her small child and traveling 45 minutes each way to the courthouse every day, the court finds that balancing those, her interests with the interest of Mr. LaRossa's health, that the Zoom platform wins out in that balance as well. Ms. LaRosse doesn't have counsel, so although we can accommodate, we have accommodated the ability for counsel and parties to confer. That's not an issue in this case. The court will accommodate the state and the CASA conferring with their clients during the trial in a way that satisfies due process. And given this court's experience with Zoom trials and the representations of everyone participating in this case, the court finds that Ms. Zayas' due process is not only satisfied by a Zoom trial, but in some ways enhanced. Because she has better access to the court this way than she would if she were to come in person. I am looking at Ms. Zayas' internet connection. It appears to be stable, and other people's, the CASA and the state's internet connection seem to be stable, so I don't have any concern about access to sufficient technology to participate, and so that also weighs in favor of a Zoom trial. This case has been on the calendar for quite some time, and if this court were to wait to try this case until the health situation is different, I don't really know when that would be because it seems to be a moving goalpost. And so there really is no reason to consider moving this trial in order for all of us to be able to appear in person without the state's counsel's health concerns rising to a level of creating an interest that outweighs getting together in person and doing this trial. So for all of those reasons, and the child in this case has an interest definitely to resolving this issue as soon as possible, as does Ms. Zayas and as does the state. So I'll just ask Mr. LaRosse, are those findings, in your view, sufficient to proceed by way of Zoom?
Yes, thank you, Your Honor.
Thank you. All right. Okay, let's talk about scheduling then. I understand that we may have some scheduling issues coming up this week. So the courts would intend to begin this afternoon with, I don't know if there's any motions, but begin this afternoon with the trial and be in session all day Tuesday, all day Wednesday, all day Thursday, and then again next week. The only time the court has a need of being in recess is next Monday morning. And so we would begin at 1:30 on Monday the 25th and then be in session all day next Tuesday, Wednesday, and Thursday, the 26th, 27th, and 28th, hopefully completing the trial by the 28th of July. So Mr. LaRosse, if you would please begin with letting the court know any scheduling issues that it should be aware of as we proceed.
I will have to defer to Ms. Ramos for her scheduling. I'm not aware of any issues that she has. The only issues that I have is that myself and Ms. Johnston-Hanks have a hearing before Judge Ferguson at 8:30 tomorrow morning, and we have informed the court that we're going to need to commence trial in front of Your Honor at 9 o'clock, so we've asked them to proceed expeditiously with that matter. It's not the sort of thing that I can really get coverage for. It's a pretty complicated motion. So my hope is that we don't run slightly over and that we're able to conclude that hearing with Judge Ferguson by 9 o'clock. Of course, I'm not 100% in control of that.
Of course. Should we begin at 9:15 tomorrow then? Would that give a cushion, or is 9:30 a better cushion?
Could we set it for 9:15, and then if there are problems, I can email the court? I think that Judge Ferguson has another matter at 9. I'm not 100% sure, but my guess is that because he set it at 8:30, it's because he has other things to do. So it's my hope that we will be able to get that done expeditiously.
Okay. Well, we'll set tomorrow, the 19th. We'll begin at 9:15, and of course, if things go awry, just let us know.
Okay, thank you. I do want to note I have a somewhat complicated matter at 8:30 on the dependency calendar on Thursday, and I'm going to do my very best to get coverage for that. If that becomes a problem, I may raise it with the court tomorrow.
Okay. And do we think we'll still be in your case on Thursday?
Well, one of the complicating factors is that Ms. Zayas informed the parties in the court yesterday or today that she has a 10:30 appointment tomorrow morning, and I have 2 separate witnesses scheduled, professional witnesses.
It's Wednesday morning. Oh, wait, is that Wednesday morning?
My mistake, Wednesday morning.
Yeah.
So depending on what the court determines to do with that situation, I may have to reschedule those witnesses, although I would prefer not to. I anticipate that I am hoping to conclude the state's case by next Monday, if not before, but that in part depends with what we do about this coming Wednesday morning.
Okay, very good. All right, anything else from your end on scheduling, Mr. LaRosse?
I don't have any, but I'll just ask Ms. Ramos to confirm whether she has any issues.
No, Your Honor, I do not have any other issues. I did find out recently that Amaya, the child in this matter, has an appointment on Thursday at 12:30. And I know that the plan was to have myself involved in that appointment as well as Ms. Zayas if she is available. I understand the court is on recess at that time, and I don't know how long the appointment will go to. So that is the only conflict, if any.
So Thursday the 21st?
Yes.
And what would the travel time be for you to attend that appointment and then get back? Because the court would intend to accommodate that.
At most 10 minutes each way.
Okay. So perhaps we start at 2 on Thursday afternoon. Let me inquire of Ms. Zayas what her travel time would be, and then we'll make a decision about what to do on Thursday. Okay. Before I get to Ms. Zayas, Ms. Cowan, any scheduling issues from your end?
No, Your Honor. Thank you.
Okay. All right, Ms. Zayas. First of all, let's talk about this Thursday appointment. That seems to be one we should resolve first. What is your travel time to get to the 12:30 appointment on Thursday?
I didn't know anything about it until she just said that. Yeah, I don't know. I've never been there before. I don't know where I'm going or what. I have no idea.
Ms. Ramos, do you mind telling Ms. Zayas where she would be going?
I have to get approval for her to be able to attend because this appointment is being facilitated by the foster parent who is the caregiver. There are concerns of safety with Ms. Zayas attending that appointment, so I may only be able to have her attend by phone. I have
to go anyway to get her record, so I might as well go up there.
The appointment is in Seattle, so if she attends in person, it sounds like it's a 45-minute drive for her each way.
Okay. So perhaps this is premature. Ms. Ramos, I understood that when you first mentioned it, you said she might attend. So now it's premature that she might attend. Is that correct?
Correct.
All right. Then let's not get into it until you know for sure whether she's going to attend in person or by phone. And can you know that by tomorrow?
Yes, I can.
All right. Very good. So figure that out, and then we'll discuss the Thursday schedule then. So Ms. Zayas, I understand you may have something Wednesday morning. Please tell me about that.
Yeah, I have an appointment at 9:30 at the airport. Sorry.
That's okay. And what kind of appointment is it?
I have to go take a drug test. It's just a mouth swab, so it takes like 5 minutes. But I don't know if they have me do it right when I get there. They might have me wait because they usually do just in case people chew gum or something before they come.
Okay.
So they might have me wait like 10 or 15 minutes when I get there and then take it, and then I can just go.
Okay. And what's the test for?
Where I start work on August 22nd for Alaska Airlines.
Okay. Do you have an email or some other confirmation of that appointment time?
Yeah, I can get that.
Yeah, would you forward that to Ms. Stronsky, the Court McCoy?
Okay.
And then we will determine if you can forward that. Do you have the ability to do that this afternoon?
Yes.
Okay, let's do that this afternoon, and then upon confirmation of that, and the reason I'm asking is just because if you do have confirmation of that, then I'm going to ask Mr. LaRosse to reschedule his witnesses, and so I want to make sure that we are certain of the time and the place and the date before I ask him to do that.
Yep, I'll do that.
All right, thank you very much.
I'm sorry, Your Honor, could I ask just to avoid ex parte communications that all parties be CC'd on that email?
Of course. Yeah, Ms. Zayas, could you include Mr. LaRosse on that email as well as Ms. Cowan?
Yeah.
Yeah, you've probably been doing that for a while, including everybody on the emails.
Yeah, sometimes, yeah.
Okay, so going forward in this trial, if there are things that I ask for you to send to my bailiff or to the court, if you would always include everyone on the email. If you don't, Ms. Stronsky's going to forward it to them anyway, so it's expeditious to go ahead and include everybody on the correspondence.
Okay.
Thank you very much. Okay, and other than your Wednesday appointment, Ms. Zayas, do you have any other scheduling issues this week or next?
No.
Very good. All right. So during the afternoon break, which will take about 2:45, I would imagine, I'm going to ask Ms. Zayas to forward counsel and the court a copy of that email. And then when we come back from break, we'll discuss the scheduling issue on Wednesday. And then Ms. Ramos will give us an update on the Thursday issue tomorrow. And we'll discuss that then tomorrow when we have all that information. So, okay. So now I'm just going to go round robin again. Mr. LaRosse, are there any other pretrial issues that we need to discuss before we begin? Are there any motions or any other pretrial matters?
There are not any other motions, Your Honor. I do have a handful of issues that I think are best resolved prior to commencing opening arguments. If I can sort of run down the list of those.
So, I'm sorry, are they motions or are they I'm not clear.
They are not motions. They are issues, for instance, addressing the fact that this is an open courtroom, addressing the application of DCYF and the Service Members Civil Protection Act.
All right, very good. Okay, go ahead.
Okay, so thank you. And I said there's a couple of different ones, but the first is addressing the matter or the fact that this proceeding is being held in an open courtroom for the court to address that on the record.
Sure. So I am sitting in courtroom West 817 in the King County Courthouse. Currently in the courtroom, as you can see on the screen, there are no observers. It is simply me and the court clerk, Mr. Mason. He's right below me and he's not visible on this camera. So we are the only two in this courtroom. The courtroom is unlocked. If anyone were to open the door and walk in and sit, they would be welcome to stay. The courtroom will remain unlocked during these proceedings, and it is for that reason, and that is all that the law requires to make this an open courtroom. This court does not broadcast its proceedings on YouTube or any other internet forum at all. Some courts do that. This court does not. If anyone wants to see what's going on in this courtroom, they have to come. We have a Zoom link that my bailiff will only give out to identified people. So if, for example, another person from the Attorney General's office, like another lawyer or another an investigator wished to watch the proceedings, they would be welcome to watch them by Zoom, but that person should identify themselves when they request an email link. I'm going to ask that if any of the parties share the Zoom link with anyone, that you make sure that that person knows they need to identify themselves when they join the Zoom. And Ms. Stronsky won't let anyone into the Zoom link who is unidentified. The reason that we do that is we can't risk having witnesses watching proceedings and then us not knowing that they're witnesses and then having watched then testifying. So that's the reason for that. Any other record that you'd like the court to make, Mr. LaRosse?
Not on that issue. Thank you, Your Honor.
Yes.
The next issue in regards to the mother's decision to proceed pro se in this matter, that motion was previously granted within the termination and the dependency proceedings. The department is not aware of any change in circumstances that would indicate that her decision to proceed by representing herself rather than via representation through an attorney is anything other than knowing, intelligent, and voluntary. If anyone else has contrary information, I would ask they present that to the court.
Ms. Cowan.
No new information that changes the circumstances from the last time the court considered this issue. Thank you.
Thank you. Ms. Ice.
Attorneys work for CPS.
Thank you. All right, go ahead, Mr. Ross.
The next question is simply one of efficiency. Because this is a bench trial and because it is on, it's assigned on rather short notice, there may be times in which the department or other parties may request to take witnesses out of order to fill in gaps, especially if there's a situation where the witnesses, for instance, who are scheduled for Wednesday morning are not proceed because the court allows the mother to attend her UA. I will need to reschedule them and as a result may have some gaps in the way the witnesses are scheduled. And so, for instance, there might be a request to call Ms. Ramos out of order to present factual testimony rather than presenting her as the department's final witness to present factual and opinion testimony, or potentially asking for the CASA to be called out of order, or if the mother comes up with a witness she wants to be called, maybe having that person called out of order. And I just wanted to alert the court to that potential issue before we begin.
Thank you, Mr. LaRosse. This court is extremely flexible with witnesses generally in all cases, understanding that people have schedules and that this case was assigned out at the last minute. So I just ask that you help me know where we are when we left off. For example, if you were to call Ms. Ramos and present an hour of Ms. Ramos's testimony and then she is interrupted by another witness, that's perfectly fine. When we resume, Ms. Ramos, if you could just assist the court in picking up where we left off. The only reason I say that is you all know this case way better than I do. And so to the extent you can keep us organized, even though we're being flexible with calling witnesses, the court would appreciate it.
Okay, absolutely. Thank you. One more question that I have, and procedurally, is that the department would like to request entry of certain exhibits consisting of court orders, filings of the mother, etc., prior to taking of testimony, and whether the court wants to address them before or after opening statements.
I'm content to do it now if that would expedite things, and if there's an agreement by Ms. Zayas, and in the absence of an agreement, then the court is happy to rule, if the court can rule. You're listing exhibits that seem to be self-authenticating, is that correct?
Yes, and also admissions of a party opponent in the sense that there are filings by Ms. Zayas.
All right. I'm happy to do that. Would you like to do that now or after we finish the rest of your list?
That's actually the end of my list, unless anybody else has any other pretrial issues.
All right, let me ask if there's other pretrial issues, and then we'll come back to this, and I'm happy to accomplish it before opening statement. Ms. Cowan, do you have any matters you'd like the court to address before we begin trial?
No, Your Honor. Thank you.
Ms. Ice, do you have any pretrial motions?
They told me this last week, so I have no exhibits. I have no witnesses because they told me this last week. I never thought I would go to trial. So what I don't have is because they told me this last week. And yes, I want it now. I don't care if I don't have anything, but that's the reason that nothing's here. Last year, when they were supposed to have this trial, I had everything ready, and they didn't have it. So, and I actually sent it in too. So basically, they already have everything, but probably threw it in the garbage. And that's all I have.
So, Ms. Ice, I will just let you know if there's anything that you do want to submit. Excuse me. You won't begin your presentation until Monday of next week. So if you'd like to upload documents to your file or submit exhibits to the court, we have time to do that. All right. So then we will turn to exhibits that the state is offering. And I will link it into the share file so I can look at them if necessary. All right. And I am ready when you are, Mr. LaRosse. Go ahead.
Thank you. And I'll just warn everybody that this is going to be an extensive list. The first group of exhibits the department is asking to enter consist of exhibits 1 through 4. And exhibit 1 is the prior agreed order of dependency entered by the mother as to Maya in 2014.
Am I allowed to say I object to these? When do I say it?
Okay, that's a good question, Ms. Ice. Let me talk through the procedure. So we'll go exhibit by exhibit. Mr. LaRosse will offer it, and I'm going to have a look at it, and then I will ask you whether you agree or object and the basis for your objection if you have one. And then I'll let Mr. LaRosse respond, and then I will rule.
Okay.
Okay? All right. So let's take exhibit 1. So you're offering exhibit 1, Mr. LaRosse?
That is correct.
All right.
And, Your Honor, in offering that, I would like to notify the court that the pretrial conference order that was entered on March 25th indicated that electronic copies of the orders entered in dependency, termination, and parenting actions involving the parents or alleged parents are deemed admissible, authenticated for purposes of admissibility. Certified copies of all criminal and civil court records regarding the parents are deemed authenticated. So I just wanted the court to be aware of those prior.
Okay, addressing authenticity.
Yes.
Okay. All right, so as to Exhibit 1, Ms. Ice, do you have an objection?
Is option C marked on the statute of authority?
I'm sorry, say that again?
Is option C marked under 1334-0306? Is C marked?
Are you asking me a question about what's on the exhibit?
Yeah.
Are you able to see the exhibit?
No, I can't see it.
Do you have your share file?
No, I never was sent a link. They said they'd send me a link to a different email. I never got a link to it.
Okay. All right, let me make sure that you have to be able to see these in order for us to carry on. So when you say they said they would send you a link, who said they would send you a link?
It's somebody at dependencycourt.gov or something like that. The documents, I guess.
Okay. All right, let me figure that out. So hang on just a second.
Your Honor, while everyone's working on that, can I take 2 minutes to step away?
Yes.
So how many years are we allowed to go back as far as evidence goes? So we can go like 20 years ago? Is that how it works? I don't know.
So right now we're just talking about Exhibit 1. So I just want to make sure you can see it.
Yeah, from like how many years ago? From like 8 years ago, I think it was. Was it 8 years ago? Yeah, it was when she was born, so it's from 8 years ago. Yes, yeah, so how far back are we allowed to go on these exhibits? I don't know the law, or the law, exhibit law. I'm not sure.
Okay. Well, do you have an objection to Exhibit 1?
Yes, I do.
All right, and what is the basis for your objection?
I was forced to arrest and sign this from crooked CPS officials who I never even read this thing. When I first started getting my kids took away, I never read any court documents. I couldn't because mentally I would just go nuts. So yeah, no, I didn't read this crap. If I wouldn't have read it back then, which I do read it now because I've been through it so many times. But if I would have read it back then, I would have never signed it.
All right.
So I was forced to sign. I was forced to sign just because they said they would terminate my rights if I didn't sign. My lawyer told me that. The CPS worker told me that. The judge told me that my rights would be terminated if I didn't sign these documents. So that's a crime. And yeah, no. So I object. This is all a crime.
Okay.
Sorry.
All right. Thank you. Mr. LaRosse, and you're offering this as self-authenticated, the certified court document, and per the pretrial order, and the factual statements in it. I'm assuming you're offering as adopted admissions of Ms. Zayas. Is that correct?
I am, and I would like to note that if there was some objection to the order, that the appropriate remedy would have been to have challenged the order, sought to have vacate the order. There's no motion to vacate or order to vacate that order, and I would object to the mother's statements about what everybody else told her as hearsay. So I would ask that the exhibit be admitted.
Okay.
Thank you.
So the court will find that this exhibit is admissible and will admit it into evidence. The statements within it attributed the factual statements.
I never seen that and I never signed it. So you're admitting something that I never signed.
Thank you, Ms. Zayas. They are adoptive admissions, and that satisfies any hearsay issue. Ms. Zayas' statements of the circumstances of her signing this order, the court will consider those. However, they go to the weight of the evidence and not the admissibility of the exhibit. So Exhibit 1 will be admitted. Let's look at Exhibit 2. Any objection to Exhibit 2, Ms. Zayas?
I object to all of his exhibits. So you might as well just go ahead and just take that as a blanket right now. I object to every single one of them. So you just go ahead and ask me why each time. You don't have to ask if, I object. I do. I object to all of them.
All right, what is the basis for your objection to Exhibit 2?
I don't understand what the point of it is.
So is it relevant?
No, but what's the point of it? What does it say that has to do with me getting my rights terminated? What does it say?
Okay. So Ms. Zayas,
my brain is gone. I don't remember signing this. I don't remember this document ever. So I don't know what the point of it is. What's the point of it? What relevancy is to terminating my rights from Amaya?
Okay, thank you, Ms. Zayas. Ms. Zayas has objected to relevance. Mr. LaRosse.
Yes, thank you. A significant, probably a pivotal issue in this case is going to be the mother's mental health and the mother's ability to work with DCYF and her lawyers and anyone in the system to remedy her parental deficiencies. And so both this exhibit and Exhibit 3, which are both declarations that she submitted during the course of the 2014 dependency cases to Amaya, demonstrate a very drastic difference in her mental state and her ability to cooperate, her ability to engage in remedial services in the interest of the child and the safety and welfare of the child over her own emotional needs. So that is the purpose of Exhibits 2 and Exhibit 3.
Trying to get me to try to force me to do services with Black people? Is that what it is?
So the court will admit Exhibit 2. Relevance is simply evidence that makes a fact more likely to be true than not true, and minimal relevance is sufficient to admit Exhibit 2. Ms. Zayas, do you have the same objection to Exhibit 3, the same basis, relevance?
Yeah, racism, reverse racism. That's what it is. It's not child welfare. I'm sorry, it's not. You don't do this to Black. You've never done this to a Black person. I guarantee you haven't.
The court will admit Exhibit 3. It is also relevant, at least minimally relevant to the issues in this case. All right, Exhibit 4 is simply a motion to dismiss. It records an act of the court. I'm sorry, it's an order of dismissal. It records an act that the court took. And what is the basis for your objection to Exhibit 4, Ms. Zayas?
I never went to any court dates during this dependency, okay? My lawyer was crooked. She went to the court dates for me. I never attended a single court date. I would sign these papers before my court date or after my court date. I had a full-time job. I didn't have time for their bullshit. They were harassing me for no reason. So basically, I've never seen any of these court documents. I just signed them. I signed a piece of paper before or she'd say she signs for me. So I never even knew she was signing my name for me, but she would just go to court and do it. I had a job. I didn't know what this court did, so I don't know what they're talking about.
Thank you, Ms. Ives. So the court will admit Exhibit 4. It is simply a public record recording an event. All right. Next exhibit, Mr. LaRosse.
Thank you. And so now we turn to a number of exhibits that pertain to the current open dependency for Amaya in case number 20-700666-0 Seattle. The first of these, excuse me, is the 72-hour shelter care hearing order, number 5.
All right, Ms. Ives, what's the basis for your objection to number 5?
Is that the shelter care order from this year or from 2000? You said number 5?
Yes, number 5.
Yeah, I never seen this or anything. I thought this was signed by my No, this is the one. This is the forgery. Yeah, this is the forgery. This is the one that they signed that as it's forgery. It's not. Aunt Danielle didn't work for King County at the time, and she was voted out in 2008 actually. But they rehired her because she said she would agree to felony. But I never signed it. Nobody else signed it. So except for the forgery by Kelsey Owens, and that's her handwriting. Kelsey Owens right there. She wrote the word commissioner, and it never went on the record. The hearing was not on the record, so you won't find it on the court docket. So yeah, I object to forgery.
All right, thank you, Ms. Ives. The court will admit Exhibit 5. Again, Exhibit 5 is a certified court document that records an event. I beg your pardon?
I don't understand why. If I object to it, why do you admit it anyway?
Well, as I explained, Ms. Zayas, each party has the right to offer exhibits, and then the opposing party has the right to object, and then it's my job to rule on the admissibility of exhibits.
So you're saying that it's okay to have, you're saying that this forgery is good. It's a good document, is that what you're saying?
I'm in process of making my record, so let me finish explaining why I'm admitting it, and that might answer your question. So the court will admit Exhibit 5. It is a certified court document that records an event. Ms. Zayas's impeachment of this document, as her allegation that it's a forgery, again, will go to the weight of the evidence, not its admissibility. And should such evidence come forth at trial, the court will consider it in its determinations. So Exhibit 5 is admitted. Go ahead, Mr. LaRosse.
You committed forgery yourself, right? Right? You can't print that document, right? You just committed forgery, right? That's what I'm hearing. I just want to make sure I'm right.
The court has admitted Exhibit 5.
So you just committed forgery, right? When you approve a forged document, you just committed forgery. I just want to make sure I'm hearing it right.
The court hasn't approved a document. The court has admitted it into evidence as a piece of evidence that the court will consider. The court is bound to hear testimony about the document, including testimony from you, Ms. Zayas. So when we get to testimony, I will hear any testimony that you have about Exhibit 5 and the circumstances of it, and I will consider that in my decision.
Got knocked out last year. All my exhibits got taken out, and I didn't have no right to say anything about it. And they were not. She didn't approve any of my exhibits. Well, the state also exhibits approved.
So Ms. Zayas, you will have an opportunity to testify about this exhibit, but right now I'm just simply.
Right now you're approving the forgery. I just want to make sure I'm hearing that right. Okay, great. Thanks.
Okay. Mr. LaRosse, next exhibit.
Yes. Next exhibit, Exhibit 6, is a copy of the clerk's minutes taken from ECR regarding the shelter care hearing that's subject to the order. Exhibit 5. As the court can tell, there's going to be some discussion about whether that hearing occurred, whether there was a forgery. I'm not going to spend time in this hearing with the audio recordings, but I am asking to submit the court's minutes for the court to, in relation to the mother's claim that the hearing did not occur.
What's the hearsay exception, Mr. LaRosse, for this one?
Well, this would be a publicly recorded document. And, pardon me, I have to look this up.
And I agree with you, it is a publicly recorded document, but it does contain statements that you're offering for their truth.
So I'm just looking to see if there's a substantive statement other than a ministerial recording of events. Pardon me one second. I believe that this would fall under RCW 544.010. However, this particular document is not an order and has not been notarized, so I'll have to get a notarized copy. I'll withdraw Exhibit 6.
Okay. All right, so the court is not admitting Exhibit 6. The state has withdrawn it, and I will not write refuse because you're withdrawing it. What's the next exhibit, Mr. LaRosse?
The next exhibit is Exhibit 7, which is an order regarding the request to withdraw and setting a litigation GAL hearing.
And is this just offered for the purpose of recording the event, not the factual allegations therein or the factual findings therein, just the event of attorney withdrawal?
It does specify certain facts that have occurred. It is a finding and order of the court, and as such would be admissible pursuant to statute, RCW 544.010, because it is a record court proceeding. It's a court order, and it is per the prior order from the court under March 25th of 2022 when we entered the pretrial conference order. It was stipulated and ordered by the court that electronic court records and copies of orders entered in dependency, termination, and parentage actions are deemed authenticated for purposes of admissibility. That covers the admissibility portion. And then the question of relevance is that these are records within the proceeding that underlies the current termination proceeding. And as a court order is not a statement of hearsay statement requiring the appearance of the judge to be cross-examined. It is a finding of the court.
Okay. I'm going to take a minute and look up this. It's time for our afternoon recess in any event. So let's take 15 minutes. We'll resume at 3 o'clock, and
okay.
I'll be ready to roll in. Thank you. So Ms. Zayas, were you able to email the information about your appointment on Wednesday?
I'm getting that right now.
Okay, thank you.
And Your Honor, while Ms. Zayas is working on that, I just wanted to interject that I had a little more to say on the question of admissibility of prior court orders.
Okay, we'll take that in just a minute. I don't want to do it while Ms. Zayas is preoccupied.
Okay.
Thank you.
Just sent it. It's in the third or fourth page, I think.
Okay, thank you very much, Ms. Zayas. All right, Mr. LaRosse, go ahead with respect to our discussion of Exhibit 7.
Yes, thank you. So it's actually been a while since I argued this, but I was able to find some additional notes. So RCW 544-010 states that the records and proceedings of any federal state court shall be admissible in evidence in all cases in Washington when duly certified by the clerk. However, the parties have entered a pretrial conference order in which it was ordered that the such orders taken from ECR were deemed admissible for purposes of authentication, and so the certification aspect is not required. And I have previously looked for case law on that specific statute and really didn't find anything of use. However, by analogy, the statute RCW 544-040, which requires admissibility of certified copies of public records, it is the case that certified copies of such records must be admitted in evidence in Washington courts. And the Supreme Court in State v. Monson, which is 113 Washington 2nd 833, it's a 1989 case, held that this is not really a rule of authentication. It is an exception to the hearsay rule. It codifies, the public records statute codifies the public records exception to the hearsay rule and contains no requirement for unavailability of the declarant. We expressly reject the rule that otherwise admissible hearsay must be excluded if it goes to the heart of an issue at trial. And so all of that goes to support the admission of prior court orders to the extent that they contain statements of fact as not being inadmissible pursuant to the hearsay rule, which makes sense because the purpose of the hearsay rule is to prevent admission of statements for the truth of the matter asserted without the ability to cross-examine the declarant. But court orders contain findings of the court. They are not out of court statements of witnesses for which the court would need to be subpoenaed to testify in another proceeding. And of course, if that were required, then the doctrines of res judicata and collateral estoppel would completely crumble because the prior court orders and the findings in those orders could never be used. The entire prior cases would need to be relitigated, or the judge who made the findings in those cases would need to be called as a witness. But again, they wouldn't be testifying as witnesses to the facts. They would be testifying as finders of fact who made determinations of fact after hearing from prior witnesses. And so that addresses the hearsay issue. And I would also like to point out that if any order is objected to or questioned by a party to a proceeding, any prior order, the remedy would have been to have appealed or sought to vacate that order, not to seek to prevent its admission in a subsequent proceeding, because the administration of justice depends on the recognition and solidity of prior court orders when individuals have been involved in multiple cases. Sorry, was the court going to say something?
I'm just ready to rule.
Oh, I just wanted to also reference ER 80323, which judgments of personal family, ruling in personal family history are exceptions to hearsay. Thank you.
Thank you. So there's several layers of barrier to admissibility of documents. The first is whether the document is authentic. And the fact that this is a court document satisfies the authenticity threshold. The second threshold is whether the contents of a certified public document are hearsay, or are they objective clerical entries of facts, not reflecting the exercise of judgment or discretion, not quoting other people, not employed by the courts. And so there is a secondary hearsay barrier to the admissibility of a document, even if it is a certified court document. This court reviewed State versus James, which talks about a certification of a prosecutor in a bail jumping case, and that was an admissible hearsay. I did review also some cases that talk about administrative findings, and there's a split between Division 1 and Division 2 with respect to whether administrative findings are inadmissible hearsay. Division 1 says that they may not necessarily be hearsay. Division 2 says they are. I did also then refer to Evidence Rule 201, which is judicial notice. I think this is the issue that the court this is really the issue before the court, is whether this court is required to take judicial notice of what prior courts have done and found in the same case. And so under Evidence Rule 201, I think this court is required to take judicial notice of prior court findings in this case, and that would result in the admissibility of Exhibit 7. So the court will admit Exhibit 7. All right, Exhibit 8.
Thank you. So Exhibit 8 is, oops, I'm sorry, I need to switch documents here. This is another order on hearing regarding the need for a GAL and the mother's request to proceed pro se.
And this is prior findings by the court in this matter. Ms. Zayas, I'm sorry, what is the basis for your objection to Exhibit 8?
Just what is the basis of having Exhibit?
Is it relevant? Is your objection relevant?
Yeah.
Okay.
I mean, all my attorneys, but how is that relevant to parenting my child?
Okay. Mr. LaRosse, relevance.
Your Honor, we're going to be having a, again, this case will pivot on the mother's mental health and her erratic behavior, and one of the issues that was the basis of her appeal of her dependency, which was denied, and we'll get to that in a moment, was whether the mother should have been appointed a GAL within the dependency. And so it is important for the court to have this record in regards to the mother's need for litigation GAL and how that has been addressed by the court throughout the course of the dependency. And so it will be specifically relevant both to her mental health, to her behaviors, and to the efforts to ensure that her rights have been protected throughout the course of the dependency.
All right, the court will admit Exhibit 8 for those purposes. Again, the contents being admissible under 201. All right, next exhibit, Mr. LaRosse.
Thank you. So exhibits 9 and 10 are sort of together. One is the order of default as to the unknown father, order of dependency, and then, regarding the dependency, there's an order of default, and then there's a separate order of dependency, actually finding dependency as to the unknown father, and those are relevant because it is required as elements of termination that the department establish that dependency has been ordered by the court as to all parental entities.
All right. Basis for your objection to 9 and 10, Ms. Zayas.
I've never seen an RCW that says you're allowed to file anything to an unknown person. I was hoping you could help me find that RCW somewhere because I don't see it.
I don't know if the court wants me to respond to that legal theory.
I don't.
Okay.
Thank you. Thank you. All right.
So there's no such law.
The court will admit Exhibit 10 under ER 201 and as a certified public document under 803. ER
So why am I objecting to them if you anyway?
I beg your pardon, Ms. Zayas?
Why am I objecting to them if you just admit them anyway? What's the point of objecting? Because when he objected mine, all my tossed. So how come he doesn't get his tossed?
Well, I will rule on any documents that you offer, Ms. Zayas, in the same manner. So.
No, but I'm saying last time the judge just threw mine out and he objected. She threw it out. But when I object, you don't do nothing. You just say, okay. I don't understand that.
So I take
I don't see an RCW.
I take document by document to determine whether it's admissible for my consideration at trial. Again, if you have legal arguments about why it doesn't make the standard for this termination trial, you can make those during trial. The only question now is whether the court should consider these documents.
Why am I allowed to object when you don't even consider my objections?
I am considering your objections, Ms. Zayas.
But you don't, because you just let him put it in there anyway, so I'm lost.
All right, so 9 and 10 are admitted. Next exhibit, Mr.
This is your favorite state.
Your Honor, would you indulge me in making a clarifying remark to Ms. Zayas, if I might, because we have over 2 years of history, and maybe it would help her understand this particular issue.
Well, you can do that when we're done with proceedings this afternoon. I'd like to get through these exhibits, Mr. LaRosse. You're free to talk to Ms. Zayas at any time, but we don't need to do that right now.
Okay.
So next exhibit, Mr. LaRosse.
Yes, so the next exhibit, first is Exhibit 11, which is the order resulting from trial finding dependency as to the mother, and then I'll be asking to address the subsequent appellate proceedings. But for now, it's just Exhibit 11.
So there's an attached email to the exhibit, and that's part of it that you're offering?
I'm sorry, I think what the court is probably referring to, but let me double check, is the approval for entry and the lack of approval for entry. So the court there had requested, you can see at the bottom of page 11, copy received, approved for entry. And so Ms. Cowan had provided her approval for entry of the findings of fact and conclusions of law following the trial. And I had attempted to obtain the approval for entry from Ms. Zayas, who was representing herself pro se at that time as well. And the attachment is her lack of approval for entry.
Ms. Zayas, your objection to 11.
Doesn't matter, you're not going to take it out anyway, so what do I tell you? Yeah, no, I don't care what you put in there.
Are you waiving your right to make a record on your objection to Exhibit 11?
I don't know what Exhibit 11 is.
We'll have a look at it.
Yeah, okay, yeah, no, on this court date, I wasn't at this court date. I never had a fact-finding trial. So, I never had a fact-finding trial at all, which is a crime, but yeah, hey, yeah, this is another fraud. I don't know. Whatever you guys do fraud, right? That's fine. Go ahead and prove it.
So the court...
My fraud. I put myself in there. I hope you approve all my fraud. You know, just for the record, since you approve all his fraud.
So the court will admit Exhibit 11. Ms. Zayas's factual information about Exhibit 11 goes to the weight of the evidence and not its admissibility. Ms. Zayas is free to present evidence about Exhibit 11 during the trial. The court will admit this as a under ER 201, and as the email attached is also a statement of a party opponent. And so Exhibit 11 will be admitted. Go ahead, Mr. LaRosa.
LaRosse, Your Honor, like the
LaRosse, sorry, I'm sorry.
That's fine.
I said it 25 times correctly, and then I'll mess it up every 26th time. Sorry.
I'm very used to that. So there are now 3 exhibits which relate to the appeal of that order of dependency, Exhibit 11. And the first of those is Exhibit 43.
Ms. Zayas, Exhibit 43?
I never appealed anything I'm talking about. I never appealed anything.
Right. The court will admit Exhibit 43 as a public record of an event. There is no assertion of, there are no statements purporting to be true in here. It's simply a record of an event. The court will admit 43, and Ms. Zayas may testify about 43 during the trial. Go ahead, Mr. LaRosse.
Yes, thank you. So the next exhibit is Exhibit 58, which is the order on petition for discretionary review by the Washington State Supreme Court denying motion for discretionary review of the decision of the appellate court upholding the dependency and dispositional orders as to the mother.
So as to Exhibit
58.
Ms. Ice?
Yeah, I sued that judge. I don't know who she is. Never met her in my life. I never appealed anything. I sued that lady, the Asian lady. I forgot her name. It's a long, weird name. I sued her. Yeah, no, sorry. Wrong person.
The court will admit Exhibit 58 is a certified public document of an event. Go ahead, Mr. LaRosse.
Yes, and the final in the series regarding the appeal is Exhibit 61, which is the mandate issued by the Court of Appeals.
All right, Ms. Ice, as to Exhibit 61?
I never appealed anything. I don't know how to appeal. I don't know what an appeal is. I've never learned the word appeal in grade school.
Okay, the court will admit Exhibit 61 as a certified public document recording of an event. All right, Mr. LaRosse, anything else?
Okay, so now we have Exhibit 14, and that's an order denying motion for change of judge made by Ms. Zayas.
And what's the relevance of this?
Again, this is a record of the mother's erratic and retaliatory behavior, which is going to be relevant to an understanding of her parental deficiencies and the consistency of those deficiencies throughout the case. And so there is, this is documentation of her attempt to remove Judge Ramsar and the subsequent ruling.
And how is this evidence of her mental status?
The issue that will be elucidated by the presentation of evidence is that Ms. Zayas is focused in a retaliatory way upon persons who she disagrees with, rather than attempting to remedy the parental deficiencies which underlie the dependency. And so this order documents her assertion post-trial that she could not obtain a fair and impartial trial before Judge Ramsar, who is hearing the dependency review hearings since trial had already occurred. And it documents that the mother submitted no evidence other than a bare assertion that she could not have a fair trial, and therefore the motion for change of judge was denied.
Ms. Ice, what's your position on Exhibit 14?
I never filed that. I never wrote it. I don't know who wrote it. That must have been somebody who had it in my account information or something. I don't know. Some ghost or something. I don't know.
At this point, the court, without further foundation, which may be late at trial, but at this point, the court doesn't see Exhibit 14 as evidence of mental status. It's showing Ms. Ice simply making a motion that was denied, but it's a motion that exists. And so the court will refuse 14 at this time, but Mr. LaRosse, upon different foundation or more foundation, the court, you may certainly offer 14 again.
Okay, so the next exhibit is Exhibit 15. This is the first dependency review order, and I don't know what this court's familiarity is with dependency proceedings, so I'll just say that there are review hearings held throughout the course of the dependency to determine compliance and progress towards reunification and what steps need to be taken in a given case. And so this is the first of those, the order resulting from the first of those hearings.
Ms. Ice, your position on 15?
It says in the order that I'm not there, so I wasn't there. It says it marked option C, RCW 13-34030. Option C means that I wasn't there. So I have no position since I wasn't there.
Okay. So Ms. Ice has taken no position on Exhibit 15. The court will admit Exhibit 15. It is a certified public record of events, and there are factual assertions in there, and to the extent that those are factual assertions by the court, which I believe they are, it's admissible under Evidence Rule 201. So 15 will be admitted.
Thank you. The next exhibit, pardon me, is Exhibit 16, and this is an order from the court prohibiting derogatory communications from the mother, Ms. Zayas. It also contains basics for the order, which are emails from the mother to the court.
Ms. Ice, what's your position on Exhibit 16?
I never sent any emails.
Okay. The court is going to refuse Exhibit 16. The court finds it's more prejudicial than probative. Unduly prejudicial, that is, than probative of the issues in this case. All right, next exhibit, Mr. LaRosse.
All right, I want to just alert the court. I may be requesting to revisit that ruling after we've had more testimony.
You may.
Thank you. Let me just double check this next exhibit. Sorry, I'm having a computer. I would ask to admit Exhibit 27, an order denying motion for change of judge, in which this particular motion documents the various allegations that the mother, Ms. Zayas, has made against the judge as her basis for the motion, and as a court order, and as something that will relate intrinsically to the issues that are fundamental to this case. It is both admissible as an order and based on the intrinsic relevance of the document.
So it is Exhibit 27, Ms. Zayas. What is your position on Exhibit 27?
You can submit it because it's true.
So you have no objection to 27?
No.
All right. Exhibit 27 will be admitted without objection by Ms. Zayas. Okay.
The next exhibit is Exhibit 29, a permanency planning hearing order. That's a type of review hearing order that takes place in dependency hearings.
Ms. Zayas, what's your position on 29?
I think they said I wasn't here on this one too.
I'm sorry, say that again.
Hold on, they said, I don't think I was there. I never signed any dependency orders. I never was there. I never signed anything, so I don't know what this is.
Okay.
I'm sorry, my daughter's really hurt.
On the first page, it says present by video. So that's the only indication that you were present by video. But if you're saying you
Is it a
weren't,
review hearing?
it is called a permanency planning hearing on
Yeah,
the 7th of May, 2021.
Yeah, I don't remember this one. Wait a second. I didn't sign it, did I?
No, you didn't sign it.
No, they don't even have my. Yeah, they took my signature line off of here. That's fine, or something like that. My signature line should be on this thing. It's not because I told them I'm not signing anything, and then they start taking my parent signature line off of the document, which is stupid because parents are part of the kid, and that's just stupid.
So you maintain an objection to 29, Ms. Zayas?
Yeah, my signature line's not supposed to be here. I'm not supposed to be at that court date, but they say it was. I don't know. If my signature line's not there, then I'm not supposed to be.
Okay, the court will.
That's my theory.
All right, the court will admit Exhibit 29. Ms. Zayas can give testimony about the circumstances of 29, the hearing reflected in 29 at trial, and the court will consider that. It goes to the weight of the evidence, not its admissibility. This is admissible as a certified public document recording an event. The findings within are admissible under ER 201. So 29 is admitted.
Thank you. The next exhibit is Exhibit 34, order on others looking to discharge attorney and proceed pro se.
Yes, admit that, please. That is the truth.
Okay, 34 will be admitted without objection.
Okay, thank you. The next exhibit is Exhibit 38, which is a dependency review hearing order.
Ms. Zayas, your position on 38?
38 or 38?
38.
38. I didn't sign it, I don't think. Did I?
No. It indicates you were present by Zoom.
You know, object because it's the wrong statute. No, that's no good.
Okay. The court will admit Exhibit 38 is a certified public document of an event to the extent there's factual statements in it. Those are admitted under ER 201, and Ms. Zayas may give testimony about the exhibit at trial explaining the circumstances, which goes to its weight, not its admissibility. 38 is admitted. Go ahead, Mr. LaRosse.
Thank you. So the next exhibit is an order on contested motion for a new service, foster care assessment program.
Number?
I'm sorry, 49.
Thank you.
Yes, that's good.
You want 49 to be admitted?
It's true.
Okay.
39, right?
No, 49.
49. Why did you put 49? We're not going to do 39?
Not at this time. Mr. LaRosse has not offered 39 at this time. He's offering 49.
Okay, yeah. Okay, I know that. I didn't know that was possible. All right, 49. I don't know what that is.
Any objection?
My signature line's not on there, so I don't know what I'm objecting. I don't care about that. No, I didn't sign that. I wasn't there.
Okay. Are you objecting to it?
Okay.
Yeah. Okay.
I don't think that's legal. No, no.
So the court will admit 49. It's a certified public document. It records only an event and an order by the court, and it is admitted.
Okay, thank you. And I should explain to everyone and sort of apologize, but the documents come in and are assembled over time in chronological order, and then when I attempt to present them to the court, I need to break them down into various types of documents, which is why the numbering of the documents that I'm requesting to enter is not sequential, and I know that can be confusing. But with that said, the next document and the final order from the dependency proceedings is Exhibit 65, which is a permanency planning hearing order entered this past June.
And your position on 65, Ms. Zayas?
This is the one that they were supposed to send me, and they never sent me. And I asked for it 1,000 times so I could file a writ to the U.S. Supreme Court. I've asked for this document so many times you have no idea. They never sent it to me, so I was not able to file a writ on time, which is 30 days after this decision. They did this on purpose. So, yeah, thanks for giving it to me 35,000 days later. Yeah, my signature line's not on here either, probably. You probably took it off. That correct. My computer's taking a while. Yeah, see, I don't have a parent signature line, so I didn't appear. Did I appear? Oh, yeah, I did appear. You know, I never signed it, so I don't know. I guess approved for entry by email attached. I don't understand what that means, but I never approved this for entry. So that my name should not be on there saying approved for entry. I never approved this document at all. I never signed it. I never did anything. So this is fraud. I've been asking for this document for over a month now. I would have filed a writ a long time ago if I would have had this document.
So
now I will.
So are you objecting to this court considering this document at trial?
I've never seen this document before. This is fraud. No.
All right. So the court will admit Exhibit 55. I'm sorry, 65. It records an event and findings by the court in this case. So it's admissible under 803 as public record and under 201 for the substance therein.
Thank you. So now I have a series of 5 orders to present that have been entered in this termination proceeding 21-70053-1-9. And the first of those, and these should be consecutive, but they are not, is 36 and 41. 36 is the order of default as to the unknown father. 41 is the findings of fact and conclusions of law terminating parental rights of the unknown father. And as to both, this also encompasses any other person claiming a parental interest in the child. So first of those would be 36, the order of default, and then 41, the actual order of termination.
Any objection to 36, Ms. Zayas?
No, please admit that because I got something to say about it. So I know who's.
Okay, so 36 will be admitted. Any objection to 41?
No.
41 will be admitted.
Thank you. Now, the next exhibit is Exhibit 50, which was an order regarding the mother's motion to discharge attorney and proceed pro se. And this one occurred on February 1st of 2022. It was followed by some subsequent orders, which I'll get to next. But this is Exhibit 50.
That's not relevant to
And
I'm afraid, Mr. LaRosse, I can't quite read the handwriting. Are you asking the court to consider the handwriting or just the typed?
I'm sorry, I'm having a loading problem. Well, the handwriting is part of the order. As I read it, it says the court also acknowledges that the communications between counsel and Ms. Zayas can be challenging, given, and then it's initialed, and then conclusions of law, given the importance of these proceedings and Ms. Zayas' desire to obtain counsel, the mother's motion is then 49.
And explain to the court the relevance of this?
The relevance is the mother's, first of all, it's additional evidence of the mother's erratic behavior when combined with the orders that are going to be submitted to the court for consideration next. Second, it's relevant in establishing a record that the mother's rights have been protected throughout these proceedings because given the nature of the appeal of the dependency asserting that her rights were not protected in that, it's important to make a record in this proceeding that her rights regarding counsel and proceeding pro se have been protected.
So given that this is filed under this cause number, is there any reason that it needs to be admitted as an exhibit? So let me just say this. First, the court is not going to admit it for finding the mother's erratic behavior. Moving to discharge counsel and then changing your mind is not necessarily erratic behavior in and of itself. Not getting along with your lawyer isn't evidence of erratic behavior necessarily. To the request that it be admitted to preserve the record that her rights have been preserved, isn't it already in the record? It's filed under this cause number.
Right. It's filed under this cause number.
So the court, Ms. Zayas, do you want 50 admitted?
No, I fired all my attorneys. I don't know.
Okay. So you're objecting to 50?
Yeah.
Okay, the court is going to refuse 50 at this time. Again, this goes with all the exhibits. If there's additional foundation and a subsequent offer of the exhibit, the court is happy to reconsider it. Okay, next exhibit.
Thank you. I'm just taking a look at the next ones to see if they have something of particular relevance. All right, there were a couple of exhibits that I was going to ask to enter, but I will not do. Now, turning to a different kind of exhibit, there are a large number of statements of Ms. Zayas, which were filed in the dependency proceeding, which the department is requesting to admit. And the first of those will be Exhibit 12. And again, these are filings in the dependency rather than a termination proceeding.
All right, Exhibit 12, Ms. Zayas?
It's taking a second to load it.
Yeah, of course.
Yeah, please do admit it. Yeah, it's true.
All right, Exhibit 12 will be admitted.
Okay, the next exhibit is Exhibit 13. Likewise, a filing by the mother in the dependency case.
Ms. Zayas, when you're ready, your position on 13?
My computer's really slow.
That's fine.
Anything? Yeah, yes.
Okay, you have no objection to 13?
No, at the time, yeah, everything I admit. If I find it, then, and I said it, then I meant what I said, yeah.
Okay, so Exhibit 13 will be admitted?
Thank you. The next exhibit is Exhibit 17.
Yes, it's true.
So 17 will be admitted without objection? All right.
The next exhibit is Exhibit 18.
Okay, Ms. Zayas, Exhibit 18.
How do these prove I'm a bad parent to my child?
Mr. LaRosse, what's the relevance of 18?
Really overt relevance is the fact that Ms. Zayas has stated that she has voided all of her releases of information for the department or court-ordered service providers.
Yeah.
And then, I'm sorry, did the court want me to proceed?
I was going to ask Ms. Zayas to respond to that relevance. The Ms. Zayas, these are being offered to show that you voided your releases of information for department services. So do you object?
Yeah.
Okay. Do you object to 18 on that basis?
Well, no, you can submit it because nobody should ever do what the department says, ever.
Okay. So Exhibit 18 will be admitted.
And I'm sorry, Your Honor, I know this is going to seem like beating a dead horse with all of these exhibits, but it will be important. Exhibit 19, again, filing by the mother in the dependency case.
Right.
Isn't the Fifth Amendment right to not persecute yourself with your own words kind of thing? Isn't that in the Fifth Amendment, I believe?
So are you objecting to 19?
He violated rights by using my own words against me.
So I can't answer questions like that, Ms. Zayas, because I am the court and I can't give you legal advice. But I would like to hear if you have an objection to 19, and if you do, what basis?
The Fifth Amendment basis. He just can't use all my words against me. He just created an entire case off of me saying, leave me the hell alone. What's that? I mean, that's not right. That's illegal.
Okay, so you're objecting to Exhibit 19 based upon your Fifth Amendment.
Listen. Evidence of child abuse. You know what evidence of child abuse is? It's like medical records, stuff like that. It's not my court document saying you guys are liars and stuff. That's not evidence of child abuse. Evidence of child abuse is evidence of child abuse. it has to have a child's name in it and me abusing the child. You know what that means? You guys should probably take a class or something. You know, if you don't know what that means, evidence of child abuse is not my court filings. That's me saying leave me the hell alone. That's not evidence of child abuse. You should be approving only evidence of child abuse. Duh. Like, you guys would know that.
So you're objecting on 2 grounds: 1, your Fifth Amendment, and 2, relevance.
It should say something like how I abuse Maya. That would be relevant.
Okay. So I'm just trying to clarify because I'm going to ask Mr. LaRosse to respond. So the first objection is Fifth Amendment privilege, and the second is relevance. Is that correct?
Nothing he's provided so far is relevance to me abusing Maya. Nothing. That's the sad part. Yeah.
Thank you, Ms. Hayes. So Mr. LaRosse, if you would respond to those objections, the first being the Fifth Amendment privilege and second being relevance.
Well, in regards to the Fifth Amendment, there is no Fifth Amendment privilege that attaches to a statement that an individual files openly with a court. I mean, so before even getting to the analysis of what statement would be contained in here, which could potentially involve criminal liability, the question isn't even reached because this is a document that Ms. Zayas previously filed with the court. So it's not exposing a statement of hers to this court that was previously hidden and now exposes her to liability. And second, it was not in any way compelling her to testify against herself because these are statements that she has previously filed with the court. So I'm sorry for being inarticulate, but it's such an unusual objection that I sort of have to process it while I'm speaking. In regards to, I'm sorry, I forgot. What was the second?
Relevance.
Relevance. Yes, so one of the issues that will be very much relevant for the court's determination at this trial is the department's efforts to work with Ms. Zayas to remedy her parental deficiencies and her amenability or agreeability or willingness to engage in those efforts and to even acknowledge that there were any deficiencies to be addressed. And so this exhibit is part and parcel of a demonstration of the difficulties in working with her and her lack of acknowledgement that deficiencies do exist.
Thank you. So the court will admit Exhibit 19. There is, to the extent that Ms. Zayas would have any Fifth Amendment privileges, she has waived it by filing the document publicly with the court. And second, the court does find that this document is relevant to the question of her willingness to engage in services.
It's sealed though, so how's it public? Right?
Well, it's filed in a dependency case, so it's published. Let me say that. It's published. So,
difference, yeah.
all right, so the court will admit Exhibit 19.
All right, and the next host of exhibits are exhibits 20 through 26. So these are all filings by the mother, Ms. Zayas, in the dependency case.
All right, Ms. Zayas, take a minute to look at 20 through 26, and then I'll hear from you about all or any of them. '23 is not in that category, Mr. LaRosse. 23 is in order by Judge Ramsayer, so the filings by Ms. Zayas are 20, 21, 22, 24, 25, 26.
Oh, my apologies.
That's all right. So as to 20, 21, and 22, Ms. Zayas, do you object to their admission?
Yeah, it only proves that they're racist. It does not prove anything about me abusing my child.
All right,
So it's not relevant.
Are we talking about 21?
I'm talking about all the ones that I made that are something about telling on them for being racist.
Okay.
That doesn't say I'm someone in the head or anything like that. It doesn't prove anything about child abuse.
All right. So let's take them in turn then. Exhibit 20, there's an objection to relevance. Mr. LaRosse?
Again, the relevance of all of these documents will be a continuous pattern of Ms. Zayas refusing to participate in services, asserting fantastical or rather unfounded legal challenges to the order of dependency that was upheld on appeal, and showing a perseveration on her own perceived injustices against her and not recognizing or acknowledging any parental deficiencies, thereby making it for the rest of the department.
So as to Exhibit 20, just looking at it and not knowing anything about the case, I don't know whether these are fantastical allegations. I can't know that, nor can I know that she's perseverating in any sort of misperception of what's going on. They are her statements, but whether they are relevant, I think depends on whether they are true. And I don't know that. So I'm assuming you can lay some foundation for 20 during trial and why it's relevant.
I can address it in Ms. Zayas' testimony.
Okay. So the court is going to refuse 20 at this point. And Mr. LaRosse, do you want to look at 21 and 22, 23, sorry, 21 and 22, 24, 25, and 26 to see if they're going to fall in that same category? Because it may be that you now realize the court's going to need more foundation before deciding on whether they're relevant.
Let me take a look here.
I can tell you 21 has some hearsay in it. So somebody else's evaluation. So that's not a statement by Ms. Zayas.
Yes, let me look at 22.
So I'm going to refuse 21 right now as currently constituted because about half of it is someone's report and would be hearsay.
All right, I'll withdraw 21 and 22 pending further foundation in the discussion of those with Ms. Zayas. 23, as the court previously noted, is not a filing of Ms. Zayas. It is a order of the court, and I would ask for entry of that order of the court. It is a court order.
And what's the relevance of it?
The relevance is the difficulty of the mother working with not only the department, not only visitation supervisors, but also with the court in terms of her profane and racist email communications. And it documents an ongoing issue which is not confined to one sphere, but again, the department's going to be asserting that the mother is overcome with rage that prevents her from focusing on anything but meeting the emotional needs around that rage. And this document is directly relevant to that.
Ms. Zayas, your position on 23?
It doesn't say how I abused Amaya.
Your Honor, may I please be heard?
Yes.
I agree with what Mr. LaRosse said on this exhibit. It directly goes to Ms. Zayas's perception of events around her, perception of reality and the world and professionals, and her interactions with them, especially when she puts that above the needs of her child. So I think for that reason it's relevant.
So it might be relevant, but again, and I understand that Judge Ramsayer has said it, and so the court can take judicial notice that this is Judge Ramsayer's decision, but that doesn't make it relevant at this point. The court will allow you to offer 23 again when there's foundation that has been laid that makes it relevant to the issues in this case. So are you going to withdraw it, or do you want me to refuse it and you can offer it again?
I'll withdraw it and offer it again.
All right.
So let's see. I'm looking at all of these filings, and I guess I can go through them with the mother, so I will. I guess I'll hold off for now on any further filing, requesting admission on any further filings of the mother. Oh, quick question. I'm sorry, I forgot to check. Do we go until 4 or 4:30?
We'll generally go until 4, unless we need to finish a witness, and then we can go to 4:15. And I also should say that we generally will be 9 to noon, 1:30 to 4. But if we are getting into a time crunch, then we can take a shortened lunch on a particular day to accommodate witnesses and begin at 1. And again, if we need to finish a witness or we're running out of time, we can go till 4:15. So,
okay.
But for today, we need to stop because it is 4 o'clock. Okay, and then so we'll continue with the exhibits in the morning, and then will we be ready to move to opening statements?
Yes, I have 2 notes. One, the exhibits that I'll be asking to admit tomorrow morning prior to closing consist of the mother's federal lawsuits and the orders on those lawsuits.
Okay.
So there's at least a dozen exhibits, maybe 20 exhibits that I'll want to go through.
Would you mind giving us the numbers now, and I'll look at them ahead of time, and I'll ask Ms. Zayas to look at them ahead of time so that we can be prepared to go forward?
Sure. I'll try to do this quickly. So 66 and 67 are a pair relating to the same case.
Ms. Zayas, would you write these down so you can look at them tonight? Thanks. All right, 66 and 67, go ahead.
68 and 69 relate to a discrete case. 70 and 71 relate to a discrete case. 72 and 73 relate to a discrete case. 74 and 75 likewise. 76 and 77 likewise. 78, 79 and 80 likewise. 81 and 82 likewise. 83 and 84 likewise. These 2 are out of sequence. 87 and 171 are both related to a discrete proceeding. And then there are 2 pending complaints that are still open, 85 and 86.
All right, thank you.
I just filed another one. You probably want to check. I filed 2 more last week, so you might want to double check that.
All right. Okay, so we'll discuss those when we get together at 9 o'clock tomorrow morning, and then we will move to opening statement. Anything else that we can...